Chapter 15, we're going to look at evidence and procedural rules for self-incrimination. Okay, so the right against self-incrimination is a privilege under the Fifth Amendment. No person can be required to make a statement against themselves in a criminal proceeding. There are situations not covered by the Fifth Amendment. So, for instance, if the statute of limitations has expired and the suspect can no longer be charged, they don't have a right against self-incrimination. If you've been offered immunity, and there's two different types of immunity. And what you really want to get is transactional immunity. So use immunity means the statement can't be used against you, and transactional immunity means you can't use the statement or what is discovered from it. Federal immunity covers state charges and vice versa. So double jeopardy is also a protection you have, and it says you cannot be retried if convicted or acquitted of a crime unless you appeal. So the prosecution cannot appeal a not guilty verdict, but they can appeal an appellate court decision. You can't be charged with a more serious crime if convicted of a lesser offense. Double jeopardy does not apply, however, if you have a hung jury. So if the jury deliberates and they can't come to a decision, then you can be retried. Jeopardy has not attached. Okay, so the Fifth Amendment only applies to testimony. You can be compelled to do other things. So you can, let's look at whether or not you can be compelled to provide bodily fluids. Okay, so you can't refuse to provide a sample based on the Fifth Amendment, and a sample can be compelled after an arrest or with a warrant. So that could be a blood test, DNA sample. A person's appearance is not protected, so the features that help identify you, but there still may be some issues here regarding the Fourth Amendment. Handwriting and voice exemplars are not testimonial. They're just for comparison use. Sobriety tests, the actions and results of a test are not protected, but questions asked during the test may be inadmissible as to content, but not your behavior. So the fact that words were slurred would be admissible, but not the particular words you used. So in Hayes v. Florida is a 1985 case, and the police were investigating several burglaries and rapes. And at the scene of one of the crimes, they found a fingerprint. So the police compel Hayes to come to the police station on threat of arrest, but they didn't have probable cause to actually arrest him. They fingerprinted him, matched it to the latent print, and then arrested him. And the Supreme Court said you can't force an individual to supply fingerprints without a warrant or probable cause to arrest. So how do you invoke this privilege? Well, what matters is what stage your case is in. So prior to arrest, you don't have any right against self-incrimination. Once you're in custody and the police want to interrogate you, we know that you're entitled to Miranda warnings. At trial, they cannot make any comments about the fact that you refuse to testify or that you remain silent. Witnesses are called, and then the witness would state that they're taking the Fifth Amendment. It is perjury, remember, if you take the stand and lie. So in 1965, in Griffin v. California, Griffin is convicted of murdering Essie Mae Hodson, and he refused to testify. At the closing, they stated, Essie Mae is dead. She can't tell her side of the story, and the defendant won't. Because they made a statement to the fact that, this defendant had invoked his Fifth Amendment rights, they're basically saying, he won't tell you, so obviously he must have done it. His conviction and the death sentence were then overturned because you can't make these statements at trial or during sentencing. So from the case of Miranda was arrested and questioned by the police and not told of his rights. So the confession was excluded. So there's 4 key issues here. What are the contents of the warning? When is Miranda required to be given? How may those rights be waived? And what are the rules for sequential interrogation? So in Miranda v. Arizona, Ernesto Miranda is arrested in Phoenix for kidnapping and rape. And after 2 hours of interrogation, he confesses. He signed a statement that the confession was voluntary, but the Supreme Court threw it out. And they basically expanded the right against self-incrimination beyond what is simply free and voluntary and created these basic Miranda rights. So the content of the Miranda warning is not exact, and you can expand the words covered, and you can slightly modify them. But what most police departments train you to do is to always read it from a card so that it's always administered the exact same way. The 4 points that need to be covered, though, are that you have the right to remain silent. Anything you say can and will be used against you in court. You have a right to have an attorney present during questioning, and if you cannot afford one, one will be appointed for you at no charge. So the right to remain silent. This begins from the time of the Miranda warning and covers any question, written or oral. As far as use of statement, we mean that it could be used as evidence or for impeachment. The right to an attorney, once you invoke this, the questioning must stop. Even if at that point you decide later on, oh, I do want to talk to the police, you have to consult an attorney first. And whether or not you're considered too poor to afford an attorney is determined by the courts. But until that's been determined, the questioning must stop. Now, there are some special cases here. In regards to juveniles, this depends upon the age and appreciation of their right. We consider anyone under 7 to be a quote-unquote infant, where there's no possible waiver, and generally you want to seek parental waiver. As far as the mentally handicapped go, mere low intelligence is not enough. It has to be severe mental retardation, and that's varied from place to place. When you're intoxicated, the waiver is allowed unless you're extremely impaired. So when is Miranda required? It's required during a custodial interrogation. So if you've had me in a class before, you might have heard me say the first thing you always want to ask the police when they question you is whether or not you're free to go. If they tell you you're not free to go, then you're considered to be in custody and Miranda is required. If they tell you that you are free to go, you should probably go, not answer any questions, and consult an attorney first. So if you're formally under arrest, you're no longer free to leave. That's a custodial interrogation. It does not cover traffic stops, though. It doesn't matter why you're in custody. And remember, it doesn't apply to questions from private parties. These protections are provided for you from the government. So it applies to questioning by the government. So in Orozco versus Texas, Orozco was questioned by officers at 4 a.m. in his bedroom about a homicide, and he had not yet been formally charged with murder. Which was found to be the case in this situation, Orozco was not free to leave. He's considered to be in custody. So once you're in custody, your right against self-incrimination is triggered and the confession is excluded. So you always want to ask, am I free to leave? That's how you determine whether or not you're in custody. Well, that's how you can determine whether or not you're in custody. So when is Miranda not required? If you give a voluntary statement or interview. During booking, things like name, address, date of birth, those are not covered. And in dire emergencies like public safety exceptions. So you might be familiar with when the marathon bombing happened and they took Dzhokhar Tsarnaev into custody. They decided that they wouldn't Mirandize him at first. And the reason for this was this public safety exception. They didn't know if there were more bombs or more attacks planned. And so they were able to ask questions that related to that. So in New York v. Quarles, we get the public safety exception. So a rape victim identified Quarles as the perpetrator. The police frisk him and find an empty gun holster. So now there's a gun holster. Where the hell is the gun, right? So they're concerned about it and they ask, where is the gun, without giving him his Miranda rights. This is a public safety exception and the gun was considered admissible. Any waiver of your Miranda rights has to be knowing, intelligent, and voluntary. Intelligent means you have the basic level of intelligence necessary to understand your rights. Voluntary means you haven't been physically coerced, no third degree, and they're going to look at the totality of the circumstances in determining if it's voluntary. Remember, though, this only applies to the police and their agents. Suspects need not state they wish to continue with the questioning. No explicit waiver of Miranda is required to continue questioning. Silence will generally allow questioning to continue. A sequential interrogation is when the police have a second interrogation, and it's often based on information they get in the first one. If the first one has been proper, it cannot be used as the basis for a second one. If the first one is voluntary but not Mirandized, the second may or may not trigger fruit of the poisonous tree doctrine. The original interrogation has to be admissible in order to impeach. And you can have a second interrogation without a new Miranda warning if given in the first interrogation. Now, it depends on how much time has passed. If enough time has passed, which isn't really, there's no amount of time determined by the courts, you could mandate a new warning. As I mentioned, if the suspect invokes their right to silence, the interrogation has to end, but you can try to renew it later on. If they invoke the right to an attorney and they're in custody, all questioning stops. No new questioning can begin until the attorney is present. You don't need to stop if the request is unclear, and this even applies to questions about different crimes by a different officer without knowledge of the request. So in Edwards v. Arizona, Edwards is charged with robbery, burglary, and homicide. And initially he cooperates, but does request to speak to an attorney. The next day, the police restart interrogations without the attorney present. And the Supreme Court said that's inadmissible. He's requested an attorney, so he needs to at least speak to one. In Burgess v. Thompson, Tompkins was arrested for homicide. He's informed of his right to remain silent, and he did remain silent. Tompkins, however, did not say he was remaining silent or ask for an attorney. So the police continued to ask questions and eventually got a confession. So just being silent is not enough. You have to invoke that right. And if you want to speak to an attorney, you need to invoke that right as well. And you need to be clear about it. You can't say, should I get an attorney? You need to ask for an attorney, and you need to say you're going to remain silent. So some special situations. Miranda will not fix an illegal arrest. The exclusionary rule will apply if the arrest was illegal. As we mentioned, any statement that hasn't been Mirandized can be used to impeach somebody. And after an arraignment or release, the police still cannot question you if you have invoked Miranda. If you've invoked your Fifth Amendment rights or your right to an attorney. And that wraps up the chapter on self-incrimination.